More than 100 years ago, we held that when an employment contract does not specify a time period for its duration, either party is ordinarily at liberty to terminate it at will on giving reasonable notice of his intention to do so. This was the statement of the Virginia Supreme Court in 2016 regarding the issue of at-will employment in the Commonwealth, and the recent decision in Texas regarding healthcare workers compelled to submit to compulsory vaccinations places the issue on whether even Arlington Public Schools can compel teachers, administrators, and staff to submit to being vaccinated as an agency of the state, which has not yet even mandated vaccines, but also how this issue plays out in the private sector, where perhaps they are free to entertain spending 3-day weekends to attempt to persuade, coax, and cajole 1,000 employees to get vaccinated. Hello, my name is Major Mike Webb. At the outset, let me state that I am not an attorney by God, and this is not, shall we say, legal advice, so much as a common sense approach based upon what we shall frame as considerable experience and intimate familiarity with both law and public health crises. So, for the next few moments, we shall explore the paradigm that has been presented in the press as a no-win situation in at-will employment with regard to compulsory vaccines, and prayerfully, if you should find yourself on the wrong side of a judge in a court, you will not have to save face with a press release about appealing all the way to the Supreme Court to hide the embarrassing fact that you actually had no case to present at all. Now, a successful attorney involved in litigation practice, note that not everyone who says he is or she is an attorney is a litigator or ever dares to set foot inside a courtroom, a very intimidating place for some people. Well, inform you that a litigator will never ask a question for which he does not already know the answer. And there is a very common sense rule why that rule holds true. While a judge, upon objection presented by opposing counsel, will shut you down in a New York minute for leading a witness, you never want to ask a question that might have the possibility of placing your own client in an unfavorable light, like maybe misrepresenting facts or misdoing the law. And in presenting argument before the bench, it is generally prudent to have a good idea about what appeals or approaches a particular judge or court may favor, opposed to just storming into court and screaming that the Nazis are coming. Not that any reputable firm might attempt that, but we have all heard stories, perhaps some of recent vintage, but I digress. But as we reviewed in an earlier video, the court has framed the issue in the context of at-will employment, and that is the game that an attorney must apparently play, a playing field upon which both employer and employee are at complete liberty to provide reasonable notice that the employment agreement has been terminated without further ado. In a prior video, we had discussed the duty and right of an employer to create a safe and accommodating workplace, intolerant as much to discrimination and sexual harassment as to health risks posed by fellow coworkers, and had explained that therefore the argument path had been constricted to a question like an ambush as to whether or not an employer, by imposing a mandatory vaccination requirement, had compelled the employee to perform some action that might reasonably be expected to create a safer workplace, and that was reasonably expected not to impose some physical harm to the employee. But we did not note at that time a very important judicial rule regarding damages if you don't want to be back in court, and it is probably prudent at this juncture to state clearly the courts will inform you that they traditionally eschew what are termed as speculative damages. Stated plainly, if you cannot convince a judge by a preponderance of evidence that you will be subjected to grave bodily harm or death, forget about it after being administered the vaccine. You will be told that you have no case, something we've heard recently. That is just the way that the proverbial cookie crumbles in a courtroom. Call your damn congressman. But, and this is your big but, Before proceeding to a logical argument arising from a perception of safety, there is another novel argument with which certainly any liberal civil rights attorney is fully aware, and which may be a good idea to review in light of the unique circumstances in this mandatory employment policy that has the state not even itself mandating for any citizen or resident making the choice for vaccination completely voluntary, wink, wink. And the seminal case regarding this, shall we say, entitlement, was decided by the Supreme Court in 1959 in the case of McElroy v. Green. Any first-year law student should know this, with the opinion for the court written by Progressive Chief Justice Earl Warren. And at the opening of the opinion, like a first-year law student briefing a case for class, the Chief Justice reviewed the relevant facts. Thusly, this case involves the validity of the government's revocation of a security clearance granted to petitioner, an aeronautical engineer employed by a private manufacturer which produced goods for the armed services. Petitioner was discharged from his employment solely as a consequence of the revocation because his access to classified information was required by the nature of his job. After his discharge, petitioner was unable to secure employment as an aeronautical engineer, and for all practical purposes, that field of endeavor is now closed to him. Let's all sob, cry, act like women in skirts. What is the importance here for present purposes? However, first, the petitioner William Lewis Green, Pussyfoot, was not a federal employee and just a federal contractor, beltway bandit, removing him from that same relationship as the hospital management in the Houston Methodist Hospital or any other private employer. But Green possessed a security clearance that had been granted to him by the federal government, importing a federal interest in the discussion, the revocation of which, from all evidence, created the controversy of his loss, not only of his job, but apparently to the satisfaction of the court that cried tears his profession as an aeronautical engineer deprived. Did the president not only offer you an entitlement to free vaccines, tell you that he needed you to do this to celebrate your 4th of July, but also, and worship in church? This briefing is unclassified, as you will. My name is Major Mike Webb, and by God, I am running for Arlington Public School Board. Let's keep Mike Webb away from our schools. Honest. Carry on. This advertisement was authorized by Mike Webb.